There he was, president of the court of the Amtsgericht in Roskilde, and now he is still vice president of the labor court in Copenhagen. Thank you very much to be here.
Thank you very much. Well, Heinz asked me in his last email to me before this meeting, would you mind bringing your professional judge's robe to Trier? Well, what I don't think that Heinz knew was that I have never, as a district judge, had a robe. But 2 years ago, an obligation for district judges in Denmark was introduced, and that was after I had retired. In fact, one of the reasons why I retired was the plans to introduce robes in the district courts. In the Supreme Court and the High Court, you all had robes for 100 years, but never in the district court before. Well, we should talk about the Danish civil law suit in first instance. And first, I would like just to take 2 minutes just to introduce my confrere. Of course, I know that you all know where Denmark is, but just you're not neighbors to Denmark, all of you. My Austrian colleague yesterday said that Austria is very close to Germany. Denmark is also very close to Germany, and in many ways you could say that also in the relation between Germany and Denmark, it's only the language which is the difference. But Denmark is a small country situated north of Germany. We have 5.5 million inhabitants and 43,000 square kilometers. The land which is most similar in relation to inhabitants is Hessen, which has around 6 million people, and as to the area, it's Niedersachsen, which has 47,000 square kilometers. Denmark, we don't like to admit it, but Denmark has had Denmark's story is very, very, very much linked to the German story. For instance, the first we had, for 400 years we had German kings. The Danish king Christian I from 1448 was from Oldenburg, and I wonder if it is that Oldenburg which where König. Is that the same Oldenburg? It was a Graf von Oldenburg, yeah? Yes. In 1460, Schleswig, which is was a Danish part of Denmark, and Holstein, part of Germany, were united forever. In 1815, the Duchy of Holstein becomes a member of the Deutscher Bund, and the Duke of Holstein was, since, I don't know, 1300 or something, the King of Denmark. So the King of Denmark was not only King of Denmark, but also Duke of Holstein. In that capacity, he was also, for instance, a member of the Deutsche Bund. So in that way, you understand that Denmark and Germany have so many links. And all our cultural inspiration has come from the south. So also the civil process principles, we have been very much inspired from Germany. Just to go to take the most important Danish-German relations since we had the war from 1848 to 50 between Denmark and Schleswig-Holstein. We had the regrettable war in 1864, where the Prussian and Austrians took Schleswig-Holstein from the Danish king. we got back 1920 the northern part of Schleswig. We were occupied, as you know, by Germany during the war. We came into NATO in 1949 and get into the EU, and that's maybe the most important thing. As I said to you, we in Denmark have been very much inspired by German legislation and German law, and that also it's also the case with the civil process. We have for 300 years studied the civil process in Germany, and we have seen some extremes. One of the extremes was Friedrich II. In 1780, he issued a cabinet order simply banning all lawyers. It was simply forbidden to be a lawyer, and of course that meant that the Prussian judge, according to this, got a very active role in the process, since the use of advocates was absolutely forbidden. Another extreme was Nicolaus Tadeusz von Gönner, who studied the German practice for the process and formulated as the first, as far as I know, die Verhandlungsmaxime. He wrote a groundbreaking book called Handbuch des Deutschen Gemeinen Prozesses from 1801, and it was studied in Denmark very thoroughly. And in Denmark we had the idea or the opinion that in Denmark what characterized the Danish civil process was in fact the Verhandlungsmaxime more than the German Roman general process, which he based his theory on. So we were in Denmark, we found that what Gönner had formulated was already the Danish principles, but at that time they were not written down. That was practice that it went in that way. Well, we got a constitution in Denmark in 1849, and what was the most important part of that was that the judiciary should be separated from the administration. And oral communication in court was the basic principle, and public access to court hearings was also a principle written down in the constitution. From that time, a administration of court law was prepared, and it took 70 years before we got a Danish act about that. We look very much at the German situation, and I just said that as curiosum, that one of the most important sources of inspiration was in Wolf processordning in the preußische Staat from the fatal year of 1864, which has since been one of the main inspirations for the Danish process. That was just to tell you a little about that we are very much inspired from what happens in Germany. I'll now give you the structure of the Danish court system, which is very simplified here. We have in the bottom 40 24 Amtsgerichte, district courts. We have 2 high courts corresponding to the Oberlandesgericht, one in Copenhagen, the Eastern High Court, and one in Jutland, Viborg, Western High Court, and then we have one Supreme Court. We have not Verwaltungsgericht in Denmark, and we have very few specialized courts. We have a labor court, which is quite special outside this system. Apart from that, in fact, we have not many other special courts. So that is the system, and that corresponds very well, I think, to the German ordinary system with Amtsgericht and Oberlandesgericht and so on. We got a reform of the judiciary in 2007, where the number of district courts were reduced from 82 to 24. Now, in each court, there are at least 6 judges, except the island of Bornholm and Baltic, where there are only 2. And that has changed the district court in Denmark considerably. Before that time, many of the small district courts, there was only 1 judge. But now you can see that there are at least 6 judges at each court. The task of the district court is civil proceedings, criminal proceedings, enforcement law, property law, bankruptcy law, and notary public. And most of the decisions of the district court can be tried by the High Court. Just give the number of judges in Denmark. We are only about 350, I think. Supreme Court, you can see there are around 20, Eastern High Court 63, and so on. But we have also deputy judges, assessors, or what we call them, and they, although they're not ordinary judges, they also sit on the bench. So when you compare the number of judges in Denmark to the number of judges in Germany, we know that there are many judges in Germany, but you should be aware that we have those Richter who also deal with the work in courts.
Let me just complete this information.
Yes.
Yesterday evening I learned that in Brazil there are 18,000 judges. Inhabitants 200 millions. We have 80 millions and 21 or 22,000 judges. Even more than in Brazil and most of all countries in Europe. This is a very astonishing fact, and there is no investigation what is the reason for this immense number of judges in Germany. There must be a historical reason, I'm sure, but I haven't found anyone who could answer this question. This is only an additional information because the Brazilians are here, and they asked me how many judges are working here when I say 21,000.
And as I told you, in Denmark, 5.5 million people and 350 judges. Yes, we got this Administrative Justice Act in 1919, and as I told you, the main procedural principles in the civil procedure is the so-called Dispositionsmaxime und Verhandlungsmaxime. And I'll just go through a few of the articles in the Danish Administration Act, which reflects those principles. For instance, the court cannot give judgment for more than the party has claimed, can only take into account the arguments which the party has brought forward. I would think it's the same in Germany, isn't it? If the party's claim was please not unclear or incomplete, the court may put questions to the party for clarification. Yes. Of course, this Verhandlungsmaxime cannot stand alone. The Verhandlungsmaxime leaves the preparation of the cases to the advocates, and if the courts don't have some control with that, it will take far too long time. So therefore you could say that the rules in the Danish law in fact modify the principle of negotiation in order to make it more efficient. And of course, if the judge don't understand what the parties mean, he has the right to ask, what do you mean? So you could put questions to the party for a clarification. But I would say the ideal in Denmark, as I know, as John has told me, it's also in England, is that the judge sits and listens and should not need to ask any questions. And when we play the play, then we will see if I am able to shut up. I don't think so, but we'll see. But also, the court may invite any part to state its position both to factual and legal questions which appear to be relevant to the case. And that means that if the judge finds that what has been presented to him, something is missing, then he is allowed to ask, why have you not claimed for that, or why have you not informed me of that? That's very legal. That's written exactly in the Justice Administration Act as it stands there. You can also invite the party to produce documents or provide evidence when the facts otherwise would state as uncertain, but there's certainly not the right, as I understand, or the obligation, as is the case in Austria, that the judge himself, without the participation from the client, can go out into the world and find evidence for that or that. That would be contrary to the Verhandlungsmaxime. Then in the district court, the party is not represented by an attorney, and I can tell you that in Denmark there's no obligation to have a lawyer at any stage of a case. No obligation. Maybe if the judge finds that he cannot deal with the case if there is not a lawyer for one party, the party can be forced to engage a lawyer, an attorney. And if he doesn't do, then there will be a default judgment. But in principle, there is no obligation in Denmark to have a lawyer to conduct one's case. And therefore, also in district courts, the judge has an obligation to guide the party and to tell him how he may protect his interests most. And that, of course, will be a modification of the Verhandlungsmaxime, because in district courts you can say, I think you should claim this or that. Evidence irrelevant for a case may not be produced, as I think it's a case, or but it's rather nice to have this provision. And if a party doesn't appear, if he takes on questions, if his answers are unclear and so on, then the courts can take that into account in favor of the opposite party. So that if, for instance, if the judge asks a party some question he doesn't want to answer it, then the judge will, there's also a legal base to say then, okay, then I will take that into account in favor of the opponent. As also here in Germany and all over, proceedings are instituted by filing a writ of summons as ein Klageschrift in German. And this Klageschrift must contain different things. For instance, detailed submission on the points of facts of the main law by the plaintiff in support of his claim. And this is then served, informed to the defendant, and then the court will ask the defendant to write a Klageerwiderung within normally 2 weeks. And if the court doesn't get an answer before that, in that period, it will enter a default judgment in favor of the plaintiff to the extent that the plaintiff's claim is found to be justified on the basis of the statement of the claim. And I understand from what I heard yesterday, that's the case in Germany too, isn't it? What I find rather interesting for you is that we have a pre-trial procedure in Denmark where you, in civil cases, so before the main trial, you have preparation time, and normally the court will convene the parties to a pre-trial hearing, and in the notice is written what should happen on this pre-trial hearing. First of all, to make it quite clear what the parties' positions are to the point of fact of law, so that you don't have to use the time of the main hearing on such details. Also, how you will organize a time frame and of an extended pre-trial procedure. And also when you can say now the preparation of the case is over, and also the date of period of the trial hearing. And that was, in fact, when this was introduced some years ago, it was a novelty, because normally you didn't fix the trial hearing before the preparation had stopped. But that meant that, of course, if the court was overloaded, it could take 2 years, for instance, before you could come to the trial. And now you can fix the trial already before the preparation of the case is over. And that has shown to be a very big advantage. Do you understand this?
Yes.
Good. What would also happen in this pre-trial hearing is, if there are objections on point of law, it should be, you should know before the main trial. Transfer of the case to the High Court of Maritime Commercial Court. Well, I told you we had not many special courts in Denmark. We had a Maritime and Commercial Court, which has the same competence, in fact, as a High Court. You have a possibility to transfer a case to the High Court if it is principal. And that means that the district court will not deal with it itself, but it will send it to the High Court. We had, like in Austria and Germany, until a few years ago, also limits as to the value of the case. The minor cases were dealt with by the district courts, and in the first instance, and the bigger cases were dealt with by the high courts in the first instance. At last, the limit was 1 million kroner, and from now on, there is no limit at all. So the only way a high court can have a case as first instance is if it is transferred from the district court, because it is of principal nature. So that's what the parties, of course, negotiate before, and it's rather few cases which go that way. It also has the If you want to, I'll come back to this after the play, in the discussion maybe, but you can appeal the judgment of a district court to the High Court. And you can also appeal the High Court's decision to the Supreme Court. And if the High Court has had the case as a first instance case, you can appeal freely. But if it has already been in 2 instances, you have to have a special permission to go to the Supreme Court. So therefore, if you transfer a case to the High Court as first instance case, that also means that there is, you're free to go to the Supreme Court if that turns out to be necessary. You will also discuss if you should use a panel of judges after the reconstruction of the Danish judicial system. As I told you, almost all courts have more than 6 judges, and that makes it possible that one case can be dealt with by 3 judges, for instance. And that's also only if there are cases of principle, and that will also be discussed if that should be the case. Maybe you can assist the expert assessors. There's a possibility to calling expert assessor to be members of the court, in fact. Yes, to be members of the court. Maybe you should discuss if you should stay the proceedings if you know that principal question is being solved by the Supreme Court in the near future. Then you might be want to postpone the hearing to know what has the Supreme Court decided on this question. It could be maybe you should refer to the Court of Justice of the European Community. Then you could also discuss if a party should provide factual particulars, request for proof documents, and so on. If you should have experts to help you with the case. How you draft questions to court-appointed experts. I think that will also, in Germany is a question of discussion. How should you formulate the questions to the experts? And so, pre-trial to the parties. Maybe it's necessary to have the witnesses heard before the main trial. For instance, if a witness is seriously ill, you want to hear the witness before he dies, then you can. Also, questions of costs and how you organize the trial hearing. Also, if you should make a conciliation procedure and alternative dispute resolution, including all those 20 questions can be dealt with during this pre-trial hearing. And it's written in the law that it is possible each party must attend the pre-trial hearing by a person duly authorized to make decisions, because the meaning to have those pre-trial hearings is, of course, to simplify the matter, cut down all questions that are not necessary. Therefore, you also have to have people who are authorized to decide on behalf of the party. And here it's written what is the meaning with the pre-trial hearing. The party's position on the points of fact to be clarified. The points which are not disputed should not be, it should also be clarified what that is. And that is, of course, the idea of the Verhandlungs- und Dispositionsmaxime. Now there's a very, very, very interesting and very practical provision. The court may permit a party process agents to attend the pre-trial hearing by use of telecommunication equipment unless such attendance is inexpedient. That is the legal basis to use telephone meetings. And I can tell you that what happens, here, it's called a pre-trial hearing, but normally the judge sits at his desk with a telephone and he has the two parties, advocates, on the other lines, and they discuss that in a telephone conversation. I have had lots of that sort of...
Only telephone or video conversation?
It could be video also. This gives the legal basis to use all electronic equipment. But nowadays in Denmark, very much of the work of the judge is that he discusses all those problems with the two parties' advocates in a so-called, in Denmark we call it telephone meeting, but it means that three persons can participate in the conversation. Main trial, the one I'll show you now in a second. And it reads that the trial hearing begins by the parties stating their claims and pleas. That's like here. Yes. Otherwise, unless otherwise directed by the court, the plaintiff must then make a brief statement of the facts and evidence must be adduced. That means that you have the evidence during the main trial. After that, the plaintiff, the defendant must each then argue their case, and in conclusion will the parties be allowed to reply. And when this oral procedure is completed, the case will be sent for judgment. And subject to the parties' consent, however, the court may stay proceedings pending the parties' decision concerning the final court. Then the parties may appeal a judgment delivered by district court to a high court. If the proceeding concerning claim a maximum €1,350, the judgment may appeal only with the permission of the appeals permission board. I can talk to you during discussion if you want to know more about that, but there's an appeal permission board which gives permission to appeal very minor cases to the High Court. And you can see a judgment delivered by a High Court as the first court of first instance may also be appealed to the Supreme Court by the parties, but if the judgment has been delivered by the High Court as the appellate court, it may not be appealed. But this appeal permission board may grant permission to a third instance review of the case if it concerns fundamental legal questions. Yes, that was my 20 minutes introduction to the Danish system.